molweni, afsheni, tobelanda. Yeah. Tomorrow is the 10th of May 2024. And there's a law of a contract that is coming tomorrow. And you must write to pass to get distinction so that you can get the good average, right? So watch this video carefully and understand everything that I'll be saying so that tomorrow you may cruise nicely, right? Okay, let's without wasting our time, let us start. So let me say this. Before I answer the question paper, I would like to explain some of the things. Then we'll go. So let me explain this in a diagram in a way that you can able to understand about the basics of a contract. All right. So that when we started to get the question there, it would be Mnandi. Right. So here, of course, my name, you know me. Here we have Munyai. Munyai, which is me. Okay. I don't want to give example by other people's name. So let me just say Munyai. Right? Munyai. And then I met someone who I should meet. Let's say I meet, let's just say, let's just say, Jane. I don't know whether this is Jane or let me just say Jane. Right. Let me put it like this. I think that this one will be more. Okay. So I am in love. Munyai is in love with Jane. Okay. They're in love. It's lovey-dovey, lovey-dovey. Then they decided to get married. Right? They decided to get married. Then they reached what we call in law consensus. That they are getting married. Wow. Then they reach something called a consensus that we are getting married. A consensus, it means that they have agreed that they are getting married. So they reach consensus by agreeing that we are getting married. All right? They agreed. Let me show by this that they have agreed. So these are the basics of a contract you must know. So Munyai and Jane are in love. Then they reach the consensus that they must get married. Then now here is the story. Then Munyai is entering into what we called he think that he's entering into a in community. Munyai think that he's getting married in community of property. Yeah, let's say this. In community of property. Let me write it like this. Munyai think that he's getting married in community of property. Whereas Jane think that she's entering into out of community of property. All right. Let me expand it to this side. Yes. There's a consensus here that they have agreed. They have reached consensus that they are getting married. However, Munya, I think, is getting married in community of property, whereas Jane thinks that she's getting married in out of community of property. Then it means that these two, although they have reached their agreement, there is it gives rise in a law of a contract. It means that these two minds are not meet because they are not contracting for the same thing. When you are not contracting for the same thing in law, it gave rise to what we call a mistake, right? It gave rise to what we call a mistake. Yes. It means that because the minds are not meeting here, here in here, it gave rise to mistake. Mistake can be material or non-material. We are going to talk about that one, don't worry. Then, Munyai knew. Then Munyai, okay, let's change the scenario a bit. Let's say Munyai then manipulated Jane into thinking that she was getting married in community of property. Now let's change here. Or no, let's not change. Then Munyai on the other side manipulated this Jane that they were getting married out of community of property, whereas they are getting married in community of property. When someone manipulates others or improperly gets a consent, immediately when you improperly get a consensus, it gives rise to what we call it gives rise to what we call the misrepresentation. It means that someone was misled. Misrepresentation will even take place if they are getting married. Munyai told Jane that let's get married in community of property. I own the business. When they get married in community of property, Jane found out that, in fact, Munyai doesn't own the business. The business is owned by his grandmother. It means that Munyai just inherited the business. Therefore, it means that this Jane was manipulated. She was misrepresented about the whole idea. Then it will give rise to misrepresentation. All right. Then, is this rendering the contract void just because there was no consensus or just because there was a misrepresentation on this side of these two? No, it doesn't render the contract valid. Why? Because both Munyai and Jane have what in law we call the remedy, right? It means that let's do whether it gave rise, it is out of a misrepresentation, whether consensus was obtained through misrepresentation or whether consensus was obtained through a mistake. Each party can rely on what we call in law. Oh, you don't know? Indirect, what we called Reliance theory. Or let's just say Insto was doctrine. I hope that the spelling is correct, but you know the correct, right? I don't think that this one is correct. I think this one is a Insto Instuas. Let me just write it like this. Maybe this is correct. I don't know. But this has nothing to do. It's correct. Yes, then I corrected so that you can see that when there is an absence of consensus, of course, it gives rise to mistake. When someone has been manipulated or the consensus was improperly obtained, it can be undue influence, it can be duress, and then it gives rise to misrepresentation. But that doesn't render the contract invalid, because both of them can be challenged on the basis of direct reliance theory or Instuas error doctrine, which means that the misrepresentation or mistake was reasonable. Okay, though this one is the one that will ensure. So here you will prove that what? That the mistake was reasonable. Let's say mistake or misrepresentation was reasonable. Okay. I don't know what is going on now, because I just want to expand. Okay, now it's good. We are good to go. You can see here that now you have to, the other party can rely on the direct reliance theory, or what we call Instuas error doctrine, which means that the mistake or misrepresentation was reasonable, or is reasonable. You can choose whatever. So I have given you the basic of a contract. It means that the person will raise what we call you will learn much when you do the delict, right? Not delict, I mean the unjustified enrichment. When you are doing unjustified enrichment, you will learn more about things that are what's going on now. This is not the place that I should be. Oh, sorry. I was saying that when you do the what we call this one, when you go to do the unjustified enrichment PVL3704, you will learn about what we call a stopper. It means that that is not a stopper. Yeah, that is a stopper. Yeah. It means that both Jane can raise a stopper so that trying to prevent Munyai from denying that there was existence of the contract, or Munyai can raise a stopper, so that Jane can not deny that the contract has been concluded. So this is the basics of a contract that I showed you. If you can read on your book and you listen here, now you know the basics of a contract. And whenever you get a question now, you can able to write whether there was contract was binding or not. If there's absence of mistake, I've already showed you that it doesn't mean that the contract is invalid. There is a direct reliance theory or Instuas error doctrine, and the mistake must be reasonable. It means that the other part can be stopped. Then we have talked about this one. Now let's go to the real thing now, the business of the day. Let's start with the business of the day. Now I'll just pick the questions from different papers and then I will explain them. I don't want to be like, remember the exam is been written. This is a closed book examination. Some people are idiots. Some students are idiots. They have been written here closed book examination. How can you write the full legislation? I mean the full case. How can you reference the case in a closed book examination? It means that you have copied from the book and you get the lower marks. There are many people who fail this thing because they are just being stupid. Do not ever, and you must do this again, never, never, ever do that in the examination. Unless if you want to get 0, do that. Do that. You must never, never in examination, when it's a closed book, you give references. You do not give references because closed book doesn't need references. So it's very, 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 very policy number 1, which you must know. And number of students fail this thing because they give references. Where is that one? I'm trying to. Okay. I'm trying to check that instruction. Yes. Where applicable, refer to case law in your answers, but do not include citations for case law and do not include footnote and bibliography. This 13.1 is different when you are writing the open book. Open book, you must show citations, footnotes, and bibliography. On the closed book, you do not show those things because they will they will penalize you for cheating, saying that you have opened the book. Many people have failed the papers because of such thing, and they will continue to fail because they do not understand the closed book examination. So let's start, guys. Question number 1 that I'm starting now is the one that is saying ABC company advertises that they have manufactured a patent medicine. The advert stated that if this medication is taken by any person, according to the manufacturer's prescription, that person will not become ill with the coronavirus sickness. And the advert further stated that the company is so confident of this medication that if anyone does get sick with this virus after taking the medication as prescribed, the company will pay the person 50,000 rand. So why then he bought, then he fell ill from the coronavirus, and then now he approaches you to give his legal to institute a legal proceedings against ABC company. So they already said that advice if there's a legal contract between ABC company. And then number 2 is that do not apply a Consumer Protection Act. Let's be honest, guys. This, when you hear that the company advertises, it means that it's a public, it's for public advertisement. So the cases of public advertisement deals with the offer that is given to the public, right? Any one member of the public can accept the offer, unless if the nature of the contract stated otherwise. So the first thing when you go to answer the question, you check the nature of the contract that is given to the public, right? Never forget that. So the nature of the contract is stated very clear that anyone who gets sick with this virus after taking medication will be compensated 50,000. They never said women. They never said old age. They said anyone. So this offer is for everyone, right? That's the first thing that you must read when you get this type of question. The nature of the contract, what the contract is about. So when you get this question, this is how you must answer. Firstly, you must tell them what is an offer. You tell them that the offer is a proposal stating clear and unequivocally the terms upon which the offerer is prepared to enter into a contract with the offeree, right? The nature of advertisement in this case, It's ABC company. The nature of advertisement is that then you state the nature of the contract of the ABC. The nature of the advertisement is that ABC company will compensate 50,000 to anyone. I forgot. Let me put it in a lowercase. To anyone who will get ill after buying and using their patent medication. Why bought their product and fell ill of coronavirus. And then you explain about the requirements of offer. Is that the offer must be firm, which by SABC was firm, must be firm. The offer must be clear, it must be complete and certain. And this type of a contract is based on the promise of reward. Then you state one, or you can state two requirements of the acceptance of the offer. Here I stated one. One is that one of the requirements of acceptance of an offer is that the offer must be accepted by the person whom the offer is intended to. So this means that since Y has accepted the offer by meeting the requirements, by meeting A, B, C requirements. Because of the nature of that contract, he accepts Y as not since Y has accepted the offer by meeting ABC requirements due to the nature of the material aspect of the contract. Then the court could force ABC company to honor the promise. The court. In English law, in the matter of Calic v. Carbolic Smoke Ball Company. That's how you must write the case. You do not write the full case, you just write that in the Calic versus Carbolic Smoke Ball Company. It was held that a firm offer could be made to the general public. In that case, a company which was in the business of manufacturing medicinal products advertised in the press that it was offering to pay a reward of £100 to anyone who have used as directed one of its products known as a carbolic smoke ball caught influenza. Mrs. Khalil used their product and caught influenza. Therefore, he claimed the reward. It was held that the advertisement was firm offer and that Mrs. Khalil had validly accepted the offer by satisfying the requirements for reward. That public advertisement it is recognized in South Africa. Then you state the case of the American Swiss Watch Company, which you know. Then South Africa is then you stated that there is a difference between this one and invitation to treaty. Then you are done. Then you get 20 marks. That was the easiest question. Let's go to another question. Let's deal with another question quickly. Remember, I told you that I would just take questions and questions and questions. So it says that Z hands over a written offer to sell his Rolex watch to X for 250,000. Z hands over a written offer to sell his Rolex watch to X for 250,000. The offer is made to X only, and it sets out all the relevant terms for the contract of sale. Z signed the written offer as the seller. X and Y are best friends, and they both sign the same document as buyers, as they want to purchase the watch jointly. X then hands the signed document to Z, who reads it. The next day, Z finds a new purchaser, D, who immediately pays him 300,000 cash for the same watch. Z accepts this cash amount and hands the watch to D. When X and Y learn that Z sold the watch to D, they approach you for legal advice. Do a detailed analysis and application of the offer and acceptance requirements and advise X and Y if they concluded a legal binding contract with Z. So, I've already set out one of the requirements. We have already talked. I said that the offer must be firm, the offer must be clear, and they said that to accept the offer, the person that the offer is intended to must accept the offer. It's one of the requirements of the offer. So it means that in this question, you will check who was the offer intended to. It's very much important when you talk about the acceptance of the offer. So the nature of the contract made it clear that the offer is made to X only. Therefore, it means that there is no way that D can enter into that contract if the contract made it clear that X is the only one who must buy. It is the requirement that X is the only one. This means that even if X and Y are best friends, they want to buy jointly. The material of the contract has made it clear that only X can buy the watch. And then besides that, we have something called mora debtors and contra and mora creditors, if you can remember. Then in this case, you must state it very clear that Z signed the written offer as the seller, XY, and then they signed the both document as the buyers if they want to purchase jointly. But then X sends the signed document to Z, which give rise to the contract. Well, then he reads it. You must know that then you apply the information theory. Do you know information theory, right? You know the information theory that when the offerer, the person who's offering the offer, reads the contract, the contract became into being. That is according to information theory. Then you apply the information theory that the contract has come into being. Now, because that is a creditor who has to hands over, because the contract gives rise to performance, which is personal right, which now Z has the one only thing, to deliver the watch. He failed to deliver the watch. Therefore, he breached what we call the moral creditor, because he has only one thing to do and he didn't perform. He has a duty to perform, he failed. Then the next day, he found a new purchaser. Even though he found the new purchaser, he has already concluded the contract with X. Therefore, the contract with X has already become available because the offer was made to X. Even if X can sign with jointly, however, the signature of X is the one that will always be recognized. Therefore, in this question, it was very clear that you must talk about the information theory. You must talk about the acceptance of one requirement, that the offer must be made for that person who is tendered to, and the offer must be firm, and all those stuff. And then you discuss some of the cases that are relevant if you are discussing the cases that are relevant. So this question was very easier. That's why I'm not writing it down. Let me go to another question. Then this one, you must just get the marks for free. With theory that the offerer learns about the acceptance is the information theory, according to which theory a contract, a letter of acceptance reaches the address. That's a reception theory. The reception theory applies to the one of the address of the offerer. It does apply to the contract, the contract law. So this one was very clear. Let me go to some challenging examination, since this one it was nothing. Concluded when of free post 6 expedition. This one was just a free marks. Let's go to another question, which are critical. This one is easy. Now let's deal with this question, which might be the last question, and therefore, if you have a question, okay, let's start by this question without talking much. Carol, an owner of an exclusive bicycle shop, advertised a special limited edition bicycle for a sale and invited the public to make an offer for the bicycle. Jane and Portia were among many other people who submitted written offers for the bicycle. Jane's offer was for $150,000 and Portia's offer was for $190,000. Although Carol intended to accept Portia's offer, she erroneously wrote a letter to Jane, whereas she accepted Jane's offer. James believed that an enforceable contract was formed, but the Carol denies this. Apply the direct reliance theory or in Stuart's error doctrine to advise if legal binding contract was concluded between Carol and Jane. So, should I take you back? Maybe let's take you back. We have talked about this one, direct is to us, and I told you that the mistake should be proven that is reasonable. And now, if that person is enforcing the contract, means that he's relying on a stopper. I told you about this thing. So it's very much clear that now you know. There's a different ways to answer this question, and let me show you in a simple way. Firstly, do you know the error in persona, right? Since that case deals with the error in persona, where you put the other person's name instead of another person's name. So we are dealing with error in persona, right? So error in persona is this one in the book, and there's a case of a cock versus oxbone, which we know everyone. So if you start here with the error in persona, which is the mistake regarding the identity of the other party to the contract. So there was a mistake regarding the identity in that case. So you start here and give the case of Oxbow versus the cock versus Osborne. Then we proceed to answer the question. So when you answer, you must remember, have you ever heard about the caveat subscriptor? Of course, you may not have heard about it. It means that you are bound by your signature. And this was decided in the case of Berger versus Central South African Railway, where the Supreme Court of Transvaal held that it is a sound principle of the law that a man, when he signs a contract, is taken to be bound by the ordinary meaning and effect of the words which appear over his signature. So it means that Carol is bound, according to this caveat subscriptor, is bound. Right? Let's go on. It is generally accepted that a signature indicates a contractor's intentions to be bound by the contractual terms in the signed agreement. However, in many instances, you will find that clients were under duress, they have been misguided about the contents of the contract, or there have been other aspects of misrepresentation. Under these circumstances, the following primary defense may assist. And now we are talking about the Eastwards error doctrine. The Eastwards error doctrine is a corrective measure when dealing with the dissenters of a contract. Simply put, a party will not be held bound to an agreement if that party mistakenly gave their consent. However, the mistake must be material and reasonable. Only one also needs to ascertain if the signatory understood all the contractual terms and whether the signature was only required to understand the contract reasonably. If, for instance, the signatory was a businessman and was signing a company contract, he should all the technical words relating to he should know all the technical words relating to the business contract. In a standard terms agreement, it will be challenging to prove mistake, but if it is intricate, it may more easily be raised. It should also be noted that if a mistake is material, then the contract is void for mistake unless a reasonable reliance is present. If a mistake is non-material, then it may be voidable. The second defense raised is a signing without a proper consent. If a person signed an agreement and did not have the contractual capacity, but in order in that one, Carol may have the contractual capacity, then we'll go to conclusion. There are many factors to consider to find a valid defense against the caveat subscriptor. Let's start with understanding the reason the person signed the agreement. You may find that the person will be bound to their contract unless it is proven that the contract was brought about due to duress, fraud, misrepresentation, undue influence, or mistake, or if the entire agreement is contrary to our laws. Then that's how other stuff that I have read about it. And then to understand more, you must go and read the case of the Absa Bank Ltd versus Serbiantowski. Or, yeah, even the name, you can hear that you can get tired. Well, I don't know whether it's an Afrikaans name or what. Then you must go and read the fact of this decision, and then you read it. I won't read for you. Then you read. Here it is very clear that in delivery judgment, Reliance J held that for the second defendant to be successful in her plea of insustuous error, she had to know that she had been misled as to the nature of terms of the suretyships, or that there had been a duty on the bank to inform the defendants of the consequences of signing the documents, which the bank had failed to discharge. In the circumstances, however, there was no indication that the second defendant had been misled by the plaintiff in a manner, but rather than Maxim Kevit's subscriptor applied and trumped the plea of insustuous error. Consequently, judgment was granted in favor of the plaintiff. So I won't read much about this case. If you want to know about this case, you go and read this case. I've already told you the case. I told you that if you need the case is a Absa Bank versus Trebertwaski, which you must go and read about insustuous doctrine and understand. However, I told you I can give you these documents, but nothing for Mahara is a national anthem. You know about this issue, right? Okay, let's read this question now. I think that this one will be the last question for me, and then so that I can give you time to read. I wanted to do more videos, but the video to be long and answer as many questions as I can. But you must know that time is running, and there are people now on my inbox. They want me to have one-on-one meetings with them, so I want to have meetings with them since they are writing tomorrow. Most of them I should have been now in, but I'm not in. As you can see, I'm still making videos. Why meet Z on 1 July and hence Z a signed written offer for the purchases of Z's Rolex watch? Why offers is for 50,000, and one of the terms of the offer stated this offer lapsed on 30 August. Z accepted the offer and signs this document on 15 August. Z posted the document to Y on 28 August. The letter reaches Y on Y September, and on this date, Y opens the letter and notices that Z has signed the document. Okay. Then, in this type of a question, there's a 10 marks which you must write in the examination. You must know that in this type of a question, so let's go, you must be talking about the offer, and then this type of a question give rise to let's write it here. Let's just write. I don't know whether it's 1.3 or no. Let's write. So let me do this quickly. Firstly, you must show that this type of question deals with option contract, right? Option contract where there is a main offer and certain time to accept such an offer, right? Then now we go and check whether X or Z who is free. Then we check who is free, who's offerer. Then it is very clear here that you must never forget this. Y is not the seller, is a buyer. Z is the seller. If Y was a seller, the things will have changed. But now Z is the seller, is the one that is selling a Rolex watch. Therefore, you must know that Z is offerio. I don't know whether I've written it well. No, spelling is not a problem. And Y is O free. Is it O free? Let me just write it like this. O free. Yes, that is an opheria and Y is O free. And you must know, number 2, that information theory applies to opheria only. And then expedition and declaration apply to free. Let me just say free. I forgot to say reception. Then you know that there's a information theory and reception theory which apply to opheria, right? Only because the information theory stated that when the opheria reads the contracts or became attention of the contract, so like reading the contract, then the contract is binding. Or the reception made it clear. Reception made it clear that when the contract reaches the address of the opheria, it has come into a being. Whereas expedition made it clear that when offeree posts the contract, it has come into being. When declaration made it clear about the contract that when offeree signs the contract, it has come into being. So let's go back to our statement now. Let's read it again. Then this Y, who's meeting Z, Z is the one that is selling a watch. Then Y is the one that is offering 50,000 to Z, saying that with this 50,000, give me a Rolex watch. Then the offer was lapsing on the 30th August. Z accept offer and sign this document on 15 August. Then when he signed it, if Z was offeree, the contract will have become into being via declaration theory. However, now Z is not offeree, it's offeria. Then it means that the contract cannot happen when he signs the document. Then Z posts a document on the 28th August. Remember, when he posts, if Z was offeree, the contract will have binding based on the what? Based on the expedition. However, the guy is not offeree. Then the letter reaches Y on 1 September. On this date, Y opens the letter and notices that Z has signed the document. And when it reaches the person, it was already after 1 September. Then the question was asking if it was a binding or not. Then this question, it is very clear that it dealing with the attention of the this question is dealing with the information theory, right? It means that it's dealing with a information theory, that it becomes into attention of a Y on the 1 of September, which the 30 has already lapsed. Therefore, the contract is not binding. Therefore, when you answer this contract, okay, let's change. If Y was of free and Z is the one that offers Y. Then if Z signed the contract and handed the contract to Y, if it was that the contract will have been signed and come into being on the 15th of August, if they are together. If the contract will have come into being by the post, which we call expedition, on the 28th of August. Therefore, the contract will have been binding. Now I understand that you understand it, right? I'm glad that you are understanding this type. So you write about the information theory, except it doesn't apply to a contract, electronics, because electronics will deal with the reception theory. It doesn't apply to the post, because post will deal with the expedition theory. The information one. So you explain those things. After explaining those things, then boom, you are done. You get the full marks. So I hope now you understand about this question. You know, I don't know. Let me just check another question. Maybe I've already dealt with this one of a 50,000. Tony sell her own drugs to Samuel for 50,000. Both Tony and Samuel are aware. So when we talk about the drugs here, we're talking about the people who are signing the contract out of the scope of the contract. It's out of our law, so it's prohibited, and nobody can sign a contract of things that are prohibited. This one will be easier to answer. Let's check another one question, which is like a very tricky. Let me check one question. Okay, let's deal with the last question. John goes to XYZ car dealership to buy a new car, and she concluded a contract with the dealership for the purchase of the car for 250,000. The manager at the dealership informs her that she's lucky as it is the last one available in the model that she chose. And the manager further informs her that they will only get delivery of this model next month, and that the new purchase price will be 290,000. On this basis, John concluded the contract with the dealership on 1 February for the purchase price of 250,000, as she did not want to pay higher price the following month for the same model car. With reference to the contract terms, John was to pay for the car by 15 February, and on 9 February, Jones paid the full purchase of a car of a price to the car's dealership. On 10 February, when Jones visits the car dealership, she is told by the manager that they received a higher offer for the same car from Mike, and they sold the car to Mike. Jones was informed that Mike had already been paid for the car, and the name has been registered on Mike's name. The manager apologized to Johnny and explained that the offer that they received from Mike was so good that they could not refuse it. It was later established that Mike was not aware that he took delivery of the car that Jones purchased. XY car dealership subsequently offers to sell Jones a car from the new fleet that will arrive on March for 290,000. Jones wants to institute a claim for damage against XY car dealership, advised Jones. This case is dealing with what? Institute a claim for the damages. So you must know those cases. So there was an offer that was open until 15th of February. Then on 9 February, he paid the full purchase of the car, meaning that the contract has come into being because he has fulfilled the obligation of a contract. And when he goes there on the 10th of February, he was told that they received a higher offer in the same from the Mike, and the car was sold to Mike. So, number one, when you deal with this question, you must deal with the fundamentals of the contract. I won't be writing it down, but I will explain to you. Number one is that the contract is based on the a good faith. You can go there on the study guide here. Let me search for you quickly so that you can know where to start. There's something called a good faith. Firstly, on this study guide. Let me just put it back. I know that good faith is yes. Uh, yes. As you can see here, they say that the cornerstone of a contract, one of the cornerstone of a contract is good faith. That the idea that parties to a contract should behave honestly and fairly in their dealing with one another. So there must be a good faith. Then the good faith has been there, and they explain a good faith here in more details. But I won't be much reading about it. I'm just showing you here good faith, equity, and public policy in a contract. Then we are dealing with a good faith, whether the dealership was is contracting in good faith or not. Good faith is the cornerstone of the contract. So you have to express the good faith. Then when you express the good faith, you have to go to the remedies. There are even the cases here about the, but it's up to for you to read about the good faith. You start from the good faith that the companies must contract in good faith to one another. Therefore, if they open an offer to me and I said that the offer will be by 15 February, therefore the dealership are bound to respect such an option. Therefore, if I paid and then they tell me that they sold to another person, it means that they are not contracting in good faith. Then there are some cases there about the good faith. That's where you started. And for I told you that when you read your memorandum, you may find that it's different. Remember, this is a contract of law. They want to challenge you how you understand it. So if you copy things from those so-called memorandums, you may be lucky to get 0. You may be lucky you get 0. That is because those memorandum are not made to show what you must be, what the answers are about. They are just telling you what you are expected to write. However, you must start from the good faith and tell them about the good faith of the contract. Then you tell them about the breach of an option, which you can seek the restitution information. And you heard about the real vindication. If you have done the property law, you know about the real vindication, which you can vindict your own car from the other person who have purchased it, who is a buyer, bona possessor, or bona possessor, or we can say bona possessor, the person who think he owns the car. So there are a lot that I can explain on this question. However, the time has run out. And if you have a question, you can come to my inbox. I gave you the number that day, and you can come. Let me repeat those numbers for you. Those that have a problem, today I'm available whole day. You can come on 061 984 2135. These are my numbers that you can WhatsApp me for information, and say that you need information on a particular question. Then I can able to assist you. So I'll be available today. It's 9th. I'll be available whole day. Then if you want to contact me, you can WhatsApp me today. So I will be stopping here, and good luck on your examination. I believe that you can pass. I believe you can maximize and get a good marks, because the good marks is the only way you can get more than 65 per average. I've already done this law. I've got more than 65. It's good when you are marketing, you know that you have an average of more than 65. Because if you have less than 65 when you apply, nobody will take you serious out there. I'm being taken serious by, there are many law firms that have been promising to me, because my average is good. My average is very, very good. And I want you, the average, to be good. Remember that your average for law should be above 65. Then anything less than 65, it will be detrimental. They won't even allow you to go to the legal aid. which is number 1. Legal aid is number 1. A disadvantaged person must start from the legal aid. Therefore, if you do not have a 65 average, then many law firms will be closing for you. So I don't want law firms to be closing to you. I don't want the papillage, the bar to be closing for you just because you never reach 65 average. I want you to get law firms and to become a lawyer. So that's why I'm helping you. So today I'll be available. You can WhatsApp me anytime. I will be available. So thanks very much, guys, for watching this video. I hope that I have helped many, and I hope that you will excel tomorrow. Have a nice day.